Ladies and gentlemen, welcome to our TACIR meeting today. We're happy to have you and the public that's observing. Unlike our committees in the House and the Senate, we do not call the roll. The roll is taken, but it's done quietly, and we do not have that announced. Today we have 3 new members, I think, making their first meeting. And so with the permission, let's have them introduce themselves and welcome them here today. Could we start with Mayor Holland of the city of Mckenzie? Would you go first, please?
Jill Holland, Mayor of the city of Mckenzie, Tennessee.
Welcome. We're glad to have you. Mary Ann Gaither, County Clerk.
Mary Gaither, Tiffany County Clerk, here on behalf of the County Officials Association.
Great. We're glad to have you here. And then the executive branch member, we have a new one, known to a few of us from a long time, and a great young man, Sammy Arnold. Would you introduce yourself,
Thanks,
Sammy?
Mr. Chairman. Sammy Arnold, Department of Economic and Community Development. It's really weird to be sitting on this side of the room. I will say that. But I'm excited to be here. Thank y'all.
Glad to have you. Any other announcements, personal orders before we get started? Anyone have anything to say? All right. Let's look at our minutes, and they're under tab 1, I think. Everyone had a chance to review the minutes to see that they are accurate and no changes are needed. We have a motion to approve. We have a second. All in favor of approving the minutes, say aye. 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 They are approved. No changes? All right. Okay, Dr. Lippert, do you mind to give us your executive director update, please?
Thank you, Mr. Chairman. So first of all, I'd like to start by updating the members on a recommendation that we had made in a 2018 report, which was our encouraging more cooperation and accountability in payment in lieu of tax agreements. As you'll recall, you had recommended at that time that the fiscal capacity formula, the portion of the formula calculated by TACIR, be updated to include the IDP pilot information that is now available that wasn't available when that model was first developed. We had been using the tax equivalency payment information, which was more of an estimate than the actual numbers that the Comptroller's Office is producing now. And so we had made that recommendation in the 2018 report. I had forwarded that recommendation in a memo to the Commissioner of the Department of Education and the State Board, asking that I be allowed to present that recommendation at the State Board. Gave them a presentation on the recommendation and the background information in May of 2018. At that time, they decided that they wanted to wait until after the change of administration before taking any action on the recommendation. And then it kind of, we'll say, got overcome by other actions that they had going on at the time. I did hear back from them in this August. I received a letter from the Chairman Lillian Hartgrove of the State Board and from the Commissioner of Education, saying that they did not believe the BEPRC, the Basic Education Program Review Committee, has the authority to make changes to our fiscal capacity formula, and that they felt that we had that authority ourselves and had requested that that if we didn't feel we had that authority, that we could request the General Assembly to take action on it. We've reviewed the statutes a little more closely since then. We don't exactly agree with their assessment, and we're continuing to discuss with them and look at our options. And I think we're going to be able to come to a resolution on this, but I just wanted to bring it to your attention and let you know that we're continuing to work on this recommendation.
Thank you, Dr. Lippert. Are there other questions or comments on it? I know that Mayor McDonald had some comments about it last time. I've had more calls on this than anything ever brought to TACIR, so I'm sure some of you all have also had calls. So, Mayor McDonald, do you have any questions or comments?
Well, just comment. Cliff was there at the BEP meeting. I happened to serve on that committee, and you know, I concur that it's not clear who has the authority to make the changes, so I'm anxious to hear what their discussions bring forward. You know, in terms of as staff, to our legislative folks, if you maybe could get some of your legal folks to look at it as well, to see if you believe that there is the responsibility or opportunity for either of these bodies to do it, or whether it's something that needs to be dealt with. But in order to get the more accurate figures, we need this tweak at least. Thank you, Mr. Chairman.
Other questions or comments? Senator Watson, welcome. I saw you walk in. We're discussing no, it's quite all right. We're discussing the issue about, do we have the right or the authority to amend the BEP? And some people seem to think we do. I think staff and the chairman, the vice chairman seem to think that we do not. I know this could have a profound impact on our budget planning and things like that. I didn't know if you had questions or comments about it. All right, sir. Would it be out of line for us to ask for an attorney general's opinion? Just a thought. Well, if no one is concerned about it, then we'll just maintain our position. Oh, I'm sorry. You're recognized, Representative.
Thank you, Chairman Carter. I just want to make sure, because I walked in with the good senator and missed most of the conversation. But are we talking about this body, TACIR, having the ability to change the BEP? Is that what we're asking?
It's not the entirety of the BEP, actually, Representative Parkinson, but rather the fiscal capacity portion of the BEP. And we have periodically updated data sources within the fiscal capacity formula as the components we use as the producers of those components have updated their methodology. We're talking about changing components in the fiscal capacity formula, which we consider to be a structural change to the formula, which in itself it has the effect of being a structural change to the overall BEP model.
Okay.
Representative Parks.
Thank you, Mr. Chair. But we are a recommending body, are we not? And the lawmakers are the changing bodies. Is that not the case, or has something changed?
I have no idea. That's why I was asking. I mean, certainly I agree with your comments about our position, the legislator's position, but the BEP is mostly black magic and smoke-filled rooms, and I don't know of anyone that fully understands it except the person that wrote it.
Dr. Fox.
Yeah, and just last comment, Mr. Chair.
There's a difference of opinion. Do we have the right to change up that formula of the funding, or do we not? I see no authority for it, but that's just my opinion. Maybe we need to get an attorney general's opinion, or certainly someone more gifted and knowledgeable than me to make that decision.
I concur with you, Mr. Chair. Thank you.
Does that need to be in a motion?
Yeah, I think it would be.
I'll make that motion.
All right, we have a motion and a second to refer this to the Attorney General for opinion of our authority and its limits concerning this matter. Does anyone want to discuss that? Any questions or comments? Representative Parkinson.
Thank you, Mr. Chair. And I'll do what go with the will of the body, but I don't understand why we're even sending this to the Attorney General. We're not that body. We're just we make recommendations for, and maybe there should be a recommendation that comes from this body, and then it should be visited by the legislature or the governor or the Department of Education. But to send this through to the Attorney General for an opinion on, I think it's a waste of time, and I think we should do what we do and what we've been charged to do. Thank you, sir.
Thank you. Other questions or comments? Mr. Chairman. Yes, sir. Mayor?
Just with the BEP staff and that commission, the feeling is it's just a tweak of the formulary, and it is not the BEP formula, it is the fiscal capacity. I've always thought of those things as one, but they're not. They're different things. And so we're using a piece of formula that was the best we had at the time, and now BEP committee is saying we need to be using the information that we now have that is the accurate IDB in place of that. So I do understand BEP's position on this. I understand that the chairman, the vice chairman, and staff have questions about whether we have that authority, and I do think it is something worth clarifying, because it is not, you're not changing anything but a formulary piece, and you're using a more current formulary piece if we do what's being recommended here. Thank you, Mr. Chairman.
Thank you, Mayor. Other questions or comments? Are we ready to vote? I don't see any other questions or comments. All in favor of referring this to the Attorney General for an opinion to give us guidance and direction in this matter, say aye. Aye. Any opposed? All right, motion passes. We'll develop a letter and send it to the Attorney General and request his assistance.
Thank you, Mr. Chairman.
Continue, please.
Yes, sir. The next item under commission updates has to do with another tweak, actually a tweak that we're making to the process we use in presenting draft reports for review and comment at these meetings. And I'm hoping I didn't oversell this change to the chairman. It's not as drastic as it may appear on the surface. What we're doing is we're going to be having slightly shorter presentations by the staff during these discussions to allow more time for discussion and comments by the members. However, we're going to be guiding that conversation using, in addition to the reports that are in your docket book, we'll be handing out one-page summary sheets. This is something that we actually had already developed at the end of the process. We developed these information sheets, and Ms. Byers will know we stole this idea from the Comptroller's office. We borrowed this idea from the Comptroller's office. Where we send out these information sheets is just a way to better convey the overall message of the report in a more succinct format. So we figured, since we're already developing these, we would use those to help guide the conversation and the questions and the discussion during the review and comment portion of the docket book. Now, any report that's already gone to final, we won't be going through that because we've already covered all this material previously. We will still be sending out those summary sheets after the reports are approved by the commission. We send those out to the General Assembly.
All right. Questions or comments? All right. What's next, Doctor?
So we've already welcomed our three new members. I would just take a moment and recognize our departing member, which was Mayor Pro Tem Kay Center, who left the commission after the last meeting. We said our goodbyes to her at that meeting, but we have prepared a certificate honoring her service with the commission, and that's been signed and will be forwarded to her. And if Kay, if you're watching, thank you very much for all your service over the years. And that is it for the commission updates. We have one staff update, Mr. Chairman, which is we just took the photo before we started here, acknowledging 5 years of service by Dr. Matt Owen, our policy coordinator. Matt, could you stand, please? Thank you. While Matt's there, I'd also note that Matt also recently graduated from the Tennessee Government Management Institute, or TGMI, which is one of the state's comprehensive 2-week training programs to develop future leaders in the state. And I would say that Dr. Owen is certainly in that cadre. So, Matt. And Mr. Chairman, pending any questions, that concludes the staff and commission update.
Right. Any other questions? Comments? All right. Next on the agenda, tab 3. That's the final report for approval on the credit shippers franchise and excise tax liability matter. Are you ready?
Yes.
Go ahead.
Thank you, Mr. Chairman. Good afternoon, members of the Commission. My name is Tyler Carpenter, and I'm pleased to be back before you to present the final report for your approval regarding Public Chapter 952, Acts of 2018, Credit to Shippers Franchise and Excise Tax Liability. The report can be found behind tab 3. Introduced in 2017, House Bill 1345 by Representative Camper and Senate Bill 1277 by Senator Norris would have created a pilot program providing a franchise and excise tax credit of 2% to any shipper that implements a turnaround policy to ensure that pickups and deliveries are performed on time. The pilot would have applied to any companies with pickups or deliveries originating or terminating in Shelby County, but would not be limited to companies with a location in that county. In 2018, the bills were amended, directing TACIR to study the proposal. The General Assembly passed the amended legislation, which became Public Chapter 952, Acts of 2018. At the May meeting, I presented the draft report, and since then, staff have made 2 changes to address concerns raised by members of the commission. Both changes can be found highlighted on page 4. The first change clarified that the pilot would not be limited to companies with a physical location in Shelby County, but would actually be available to eligible counties both across Tennessee and from outside of Tennessee. The second change addresses the claim made by proponents of the credit that improved efficiency would reduce the effects of the driver shortage by making truck driving more desirable, but the proposed legislation does not include a method to track such an effect. Given that Tennessee would be the first state to implement such a credit, it is unclear that the number of drivers would increase. The recommendation of the Commission that the proposed credit not be adopted at this time remains unchanged. And with that, I welcome any questions and ask for your approval.
Thank you, Mr. Carpenter. Questions? Comments? We have a
Second.
motion to approve and a second. All in favor of approving the final report, say aye. Aye. Any opposed? All right, it's approved. Thank you, Tyler. That's been quite an effort. You've done a great job. Thank you. All right, next under tab 4, House Bill 2265, Senate Bill 2146, Consolidation of Municipal Elections. The final report is here today for approval. Ms. Berry?
Good afternoon. Thank you, Mr. Chairman and members of the Commission. My name is Jennifer Berry. I'm presenting the final report addressing the consolidation of municipal elections for your approval. I will briefly remind you of how we got the study. I'll remind you about our recommendations, and I'll explain one clarification we made to the report since we presented the draft report at the last meeting. The report was prepared in response to House Bill 2265 by Representative Cameron Sexton and its companion bill, Senate Bill 2146 by Senator Gardenhire, which were introduced in 2018 because of concerns about low voter participation and the cost of municipal elections, which cities pay for when they don't coincide with countywide elections. As amended, the legislation would have required cities with private act charters to change their election dates to coincide with either the regular August or November election by 2022. In response to a question at the last meeting, we made one clarification to the report on page 32. We added a short explanation to clarify what voter, ballot, and election fatigue are, and the report now says, while it is easy to see drop-off in elections results, it is difficult to fairly and accurately compare ballot drop-off in different elections because turnout is affected by many different variables. Finally, the recommendation in the report remains the same. It says, although aligning municipal elections with countywide elections usually improves turnout and saves cities money, local government representatives are concerned about mandating that city elections coincide with county, state, or federal elections. Because local officials understand the unique needs and issues of their communities and when elections work best for them, our recommendation is that the Tennessee legislature continue to authorize, rather than require, municipalities with private act or general law charters to change their election date by ordinance to either August or November general elections in even-numbered years. The legislature could consider adding one additional even-year election date, the presidential primary election in March, as an option for municipalities to move their election date. Although the presidential primary is held every 4 years, not every 2 years, including it as an option for municipal elections in Tennessee might encourage city leaders to move their election dates to coincide with another countywide election. Adding this option could help balance the potential savings and increased voter turnout resulting from election consolidation with municipal government's authority and flexibility to decide what works best for their communities. So thank you for listening this morning. I'm happy to answer your questions and ask for your approval on this report.
Thank you, Ms. Berry. Questions, comments? We've got
Mr. Chairman, I move it.
Mayor Small Sides here. Surely someone has a question.
I move it.
All right, we have a motion. Do we have a second? Motion and second to approve the report. Any questions? Seeing none. All in favor, say aye. Aye. Any opposed? No. All right, one. We'll note it. Report passes. Finally. Thank you, Ms. Berry. You're back again, I see.
Yes.
Public Chapter 827, Acts of 2018, Global Positioning System Monitoring, a draft report for review and comment. Ms. Berry?
All right, now we'll be presenting the draft report for your review and comment addressing GPS monitoring as a condition of bail for defendants accused of domestic violence. The draft is behind tab 5, and we'll present the final report at the December meeting. And right now, you are receiving for your reference a one-page summary of the draft report. And you'll also receive a handout that is an updated version of Table 1 in the report. And it replaces the table that's in the docket book, which I'll talk about later, a little bit later. First, I'll give you a brief overview of how we got this study and some background information, and then explain our findings and recommendations.
All right.
Should I wait till everyone has their handouts?
Just about.
Okay.
Thank you.
No, you're fine.
All right.
All right, Ms. Berry?
Because of the potential of global positioning system, or GPS, monitoring of defendants in domestic violence cases as a tool to improve victim safety during the pretrial period, the General Assembly passed Public Chapter 827, Acts of 2018, directing TACIR to conduct a study of the effects and implementation of GPS monitoring as a condition of bail for defendants accused of stalking, sexual assault, domestic abuse, and violations of orders of protection. Although domestic violence has been decreasing the last few years, it remains a common and serious issue in Tennessee, and the state has taken steps to address it to keep victims safe. One of the most dangerous periods for victims is the pretrial period, after the alleged abuser has been charged with the crime and has been released pending trial. Under the Tennessee Constitution and state statute, criminal defendants have a right to bail in all non-capital cases. If they make their bail, they are released. When determining conditions of release for defendants accused of domestic violence, magistrates are required to review the facts of the case and determine whether the defendant is a threat to the alleged victim or to public safety, or is reasonably likely to appear in court. If the magistrate finds the defendant is a threat or is unlikely to return to court, they are required to set at least one condition of release. In domestic violence cases, these conditions usually include bonds and no-contact orders. Another condition available to magistrates in Tennessee is pretrial GPS monitoring. In Tennessee, local governments are responsible for pretrial GPS monitoring, not the state. And just to refer you to Figure 1 on page 13 shows the section of statute that for determining conditions of release. The report presents two key findings. First, although there are a wide range of views and findings about pretrial GPS monitoring and its effectiveness, the majority of stakeholders and literature agree that it is a tool that can improve victim safety, and it is most effective when implemented within a larger coordinated system that includes strong interagency partnerships and cooperation and commitment from the stakeholders. And second, the second finding is that funding it is a challenge. I'll start with the first key finding about using GPS within a coordinated system. The literature, interviews with stakeholders, and the outcomes of GPS monitoring programs like the pilot program in Memphis and Shelby County, and programs in jurisdictions in other states that we found, such as in Connecticut, they offer ideas and lessons learned for communities that are interested in implementing similar pretrial GPS programs for victim safety. The draft report explains that because of the unique and complex nature of domestic violence, GPS monitoring with the intent to keep victims safe is most effective when implemented within a well-coordinated system. One example of why this is important is that to keep victims safe, monitoring needs to be real-time, or meaning it's done 24 hours a day, 7 days a week. This requires coordination and communication between agencies so that staff are available to constantly monitor and immediately respond to alerts and assist victims, as opposed to responding the next day, for example. Pages 28 through 31 in the report briefly describe the Memphis-Shelby County program, the program in Connecticut, as well as examples of other programs in Denver, Colorado, and Charlotte, Mecklenburg, North Carolina. And then pages 20 through 28 provide a lot more detail about the idea of coordinated systems. So based on these findings, our first recommendation relates to the idea of having a coordinated system. The draft report recommends that to help maximize GPS monitoring's effectiveness for increasing the safety of domestic violence victims during the pretrial period, local jurisdictions should consider adopting it as one component of a larger coordinated community response, which includes the strong interagency partnerships, cooperation, and commitment from stakeholders, and services such as lethality assessments, domestic violence high-risk teams, and family safety centers. Regardless of whether local governments choose to implement GPS monitoring programs, law enforcement agencies should be encouraged to adopt validated lethality assessments because of their effectiveness as a tool to identify victims most at risk of serious harm or death and to help prioritize their access to services. Lethality assessments, sometimes also referred to as danger or risk assessments, use victims' responses to a series of standardized questions to help law enforcement at the scene of the incident and victim advocates determine the danger a victim is in and immediately connect high-risk victims to services and safety planning in an attempt to keep them safe. The Tennessee Law Enforcement Training Academy already provides training for one specific validated assessment tool called the Maryland Lethality Assessment Program, usually referred to as the LAP. This program is being provided at no cost to local law enforcement agencies because it's being funded by a grant through the State Office of Criminal Justice Programs. And this Maryland LAP is a program that includes a lethality assessment tool and a specific protocol for victims who are identified as high risk. To participate in this program and receive training, law enforcement agencies are required to adopt and implement the Maryland LAP as part of their agency's protocol. And lethality assessments kind of in general are described on page 26 in the report, and Tennessee's lethality assessment program is described on page 16. And now I'll address the second key finding about funding pretrial GPS monitoring. The cost of monitoring varies depending on how it is implemented. And the cost ranges from about $4 to $15 per defendant per day. The report includes more cost information on pages 31 and 32. Finding sufficient and recurring funding is an obstacle to implementation of pretrial GPS monitoring in domestic violence cases. In Tennessee, funding sources include local revenue, the defendants, grants, and the state's electronic monitoring indigency fund called the EMIF. Although Tennessee law authorizes magistrates to order defendants to pay for monitoring, the majority of defendants are indigent and can't afford to. While grants are often used to fund programs initially and can be helpful to get a program started, they're limited to specific timeframes and are not sustainable long-term funding sources. For example, the Memphis-Shelby County 3-year pilot program, which ended on June 30th of this year, was grant funded. As of July 1st of this year, Tennessee's Electronic Monitoring Indigency Fund, the EMIF, is now available to pay the cost of pretrial GPS monitoring for indigent domestic violence defendants, up to $200 per month per person per device. Local governments who choose to participate in this program cover 50% of the cost for monitoring indigent defendants in their jurisdictions, and the other 50% is matched by the state. This fund is also used to pay for other types of electronic monitoring, specifically drug and alcohol monitoring devices, and for DUI cases. However, depending on how many local governments choose to participate in the EMIF, current funding most likely will not be enough to cover the state's share in all domestic violence cases. Court fees for domestic violence and DUI offenses are earmarked for the fund, but have resulted in approximately $300,000 in annual revenue, according to the Treasury Department staff that we talked to. Although the state's fiscal year 2020 budget included an additional $1.5 million for the EMIF, this amount is non-recurring. In addition, the EMIF currently prioritizes funding for ignition interlock devices in DUI cases, with the cost of the GPS monitoring covered only with money remaining after the ignition interlock devices are paid for. It is also unclear how many local governments will be able to match the cost or choose to participate in the program. The EMIF is described in more detail on pages 33 through 35. And turning your attention now to the updated table that you received as a handout, it replaces the table that's on pages 36 and 37. It shows a few hypothetical scenarios for the estimated cost to state and local governments for monitoring indigent defendants, depending on the number of days they're being monitored and the cost per day, and considering the $200 per day, per month maximum, per day, per person, per device. We limited the scenarios to intimate partner violence for stalking, sexual offenses, and aggravated assault. Based on these findings, given the importance of operating a pretrial GPS program within a larger coordinated community response, the report recommends, if the General Assembly appropriates additional funds to the Electronic Monitoring Indigency Fund, specifically for real-time GPS monitoring of domestic violence defendants, it should require that local governments drawing money from the fund, at a minimum, adopt a validated lethality assessment tool to both help identify which domestic violence victims are in the greatest danger and immediately connect those victims with services to keep them safe. And finally, I'll move on to one last recommendation. The number of defendants subject to GPS monitoring will also affect program costs. Because defendants have not yet been convicted of a crime, deciding which defendants should be monitored requires balancing victim safety with defendants' rights. Following a recommendation in its preliminary evaluation, Memphis and Shelby County determined that going forward, Their program would be limited to the subset of domestic violence cases involving intimate partners. And our report's final recommendation is that other local governments adopting pretrial GPS monitoring programs may also choose to prioritize high-risk cases and certain types of offenses, including intimate partner violence, strangulation, stalking, threats involving firearms, or violations of protection orders. With that, I thank you, and I look forward to your input and discussion.
Questions or comments? Thank you, Ms. Berry. Mayor?
Thank you for this report. I had the blessing for several years of providing pro bono representation to abused women through a shelter in Knoxville. And so I appreciate that we're not doing enough to protect victims. And it's with that in mind that I'm curious as to what you would perceive as the role of the victim and her advocate in this process, because I can tell you, there were men I dealt with that needed to be in jail. They wouldn't let a bracelet slow them down unless you were going to have 30-minute response time. When they decided they were going to go maim and kill or beat their wife, they were going to do that. They'd either get stoned or drunk or whatever, just be mean. If they couldn't get her, they'd go get mom and dad. And so it seems to me that however we do these assessments, we have to provide a clear role and the ability for the victim and her advocate, and most of them need an advocate, for that advocate to have a considerable say as to whether or not a particular person is released, with one of these detective devices. Now, some of you all know from my time here, I think we have to do everything we can to reduce jail populations. We have way too many people sitting in jails. It's costing local government way too much money. We got to find solutions. But what concerned me here was, as I read this, what do we do to make sure the victim has an appropriate say? And I guess follow-up, has there been any effort, any type of study conducted to see what percentage of the time these procedures fail? In other words, what percentage of the people, there has to be a response. In other words, they violate the terms and they go where they weren't, the alarm sounds, and somebody has to respond and give us an efficacy of how well this works.
To address your first question, that's one of the most important findings that we learned was that GPS monitoring is a tool, an optional tool. It doesn't guarantee safety. It, someone wearing a monitor can still go hurt somebody. So that's why we emphasized, and every stakeholder I think we talked to, and the majority of stakeholders we talked to in the literature and programs in other jurisdictions all agree that that's why the coordinated response is so important, and a huge part of that coordinated response is working with victims advocates. And I think everybody agrees that victims advocates are a critical part, and victim participation in the program is also really important, and that's a challenge for a variety of reasons because of the nature of domestic violence and working with victims. So the victim advocates are trained to work with victims, so they're a critical piece in a coordinated system and in implementing a GPS program. So that's part of it, and that also the lethality assessment is another tool that law enforcement and victims advocates are trained to use, and the law enforcement and victims advocates are partners when they use that tool, so they get trained together. and that tool can't be implemented without that partnership. So the law enforcement officer responds to the call, assesses the situation, asks the victim the set of questions, and based on their responses, there's a score produced, and the law enforcement officer determines a level of risk and then immediately contacts a victim advocate. That's part of the protocol. So yes, it's, I think everything pretty much that we looked into agreed that that's a critical component of a GPS monitoring program, is the cooperation and involvement of victims advocates and other agencies, the prosecutors, the DAs, the courts. Everyone needs to be working together and making sure that the response is coordinated.
And I appreciate that. But often the window from arrest until a decision has to be made on bail or pretrial release is a very short window. Yeah, my experience has been, unless you have someone who's willing to be on call that day, right, for a period of time, there may not be a victim advocate present. And I suspect in a lot of counties, there's probably not. That's just speculation on my part. But that would be my concern. I mean, now we place the huge burden on the judge to based on the best evidence he or she has to determine whether or not how this person should be handled pre-trial. And I applaud the idea that this is one more tool that those judges have. But my concern is there will be tremendous pressure to use this because of the economic pressures local governments face with our jails. And so there's going to be pressure on the judge to use it. And I guess what I would want this report to do, and if we could beef it up a little bit, just focus when we are looking at the assessment that we make sure first and foremost the question is what is in the best interest of the victim and how do we ascertain that? And it may not be what a law enforcement officer does on the scene, and those men and women are, I mean, you talk about people already overburdened. I mean, they got their mental health people, their drug people. I mean, they have more. They have to wear more hats now, and now we're saying we're going to put one more hat on them. I guess I would want our report to simply emphasize the victim and the need to make sure the victim has appropriate representation as we do this.
Thank you.
Representative Love, I had you on the list next. Oh, okay. Hey, how you doing? Mayor McDonald?
So, having served with the Crime Commission in Shelby County for a number of years and having served particularly on domestic violence, the thing that drew me to it was a study that they did at the University of Memphis that showed that domestic violence cuts across all socioeconomic, any line you can draw, domestic violence crosses it. And so it's a huge problem. But one of the things that we also found was, and I don't know if this is true in every county, because I just have experience with the Shelby County group, but what do they call them? Administrative judges, is that the right phrase?
I wouldn't think so.
Say it again?
Administrative law judge?
Yeah, so they have a number of those in Shelby County because there's such every night, 24 hours, they're coming through to be heard, these cases, and to be set for a hearing, but they have to determine whether these requests to have people stay away from each other, and this would be along with that. One of the problems we found was the lack of willingness of those people to take training. So one of the things I would like for us to look at and consider is that there be some requirement that if somebody's determining this, that they have had training to do that. So I would just, based on my experience in that vacuum, that would be something I'd be interested in looking at. Thank you, Mr. Chairman.
Mayor, I think those are commissioners in your county, I believe, that do that, not administrative law judges. Other questions or comments? If I could address a couple of things, for the first 5 years that I served as a Sessions Court judge in Hamilton County, we did not have commissioners. And so these decisions were made by judges every day. Domestic violence is an enormous problem. And I appreciate your comments. It cuts across all lines. You can't predict it. It might be the poorest, most uneducated, or it might be the wealthiest, most educated. It knows it knows no discrimination. It applies universally. And it's a much bigger problem than I ever imagined before I went on the bench. What becomes very clear when you hear these cases, that these cases are not so much about violence as they are about control. That person, and I did have in 9 years 3 ladies that were accused of it and later pled guilty. The vast majority were men. It was all about control. She or he is going to do what I want them to do, and I'm going to harass them, and I'm going to do things to force them to do what I want them to do, ending up when nothing else works with violence. That seems to be what I saw. Here's the problem. The law requires now a 12-hour holding period, or a cooling off period, we call it, Mayor Bickers. So we do have a 12-hour period there where we can get some help. My concern was simply this. Every one of these issued at that time, and I thought still the law, but apparently it is not. At that time, you could not be released without an order requiring you to stay away from that person. You had to issue certain conditions of bond, one of which was to stay away. I drew that form order, and of the boxes you could check of everything that you could require to stay away and not go to where they may reasonably be predicted to be was printed. The judge could not decide whether to do that one or not. It was pre-printed in the form, and that way it worked. My problem was in explaining to these offenders that I won't say exactly what I said because it might not be very complimentary of my legal background. But basically, I would explain to them that they're no longer the bully, I'm the bully. And that they're going to stay away from that particular person, or I then get to lock them up without a bond. Remember that unless they're charged with a capital offense, I must give them bond. So it's not a matter of how much money do they have for their bond. It's not a matter of what conditions of bonds I issue and write on a sheet of paper, because that was prior to the 12-hour holding period when I was doing a lot of this. When they left, they would laugh. What good did that paper do that generally young woman? Not always, but the vast majority was. So my concern was 3 weeks later when I am in court, she is there testifying to a violation of that order. We're trying to decide whether to lock him up or not. She says he was standing on the porch of my house, kicking my door, called me on his cell phone, told me he had a gun, he was coming in and kill me. He responds, I was 40 miles away with my friends in another state. How in the world do I know who is telling the truth? In one particular case, I subpoenaed the cell phone because they both agreed that they had talked by cell phone. And so at that time, we could get cell phone tower pings, as we called them. And I got those, and 60 days later it came in, and the gentleman was, in fact, in Lafayette, Georgia, not on the porch of the lady's house. He had been imprisoned and barred in Georgia, imprisoned and barred in Alabama, and so then it had come to Tennessee. That was an abuse, a tremendous abuse of the system that particular lady had used to use the laws that we've developed to protect in order to abuse. Now, in my 9 years, that's the only one that I did catch. My problem with our study, and what I hope we will do, is understand a couple of things. That this in no way protects anyone. It provides proof. Now, since then, and apparently at some committee meeting I was at and made a comment, I got a call from someone in Utah or somewhere, some company, that tells me that their program and other companies' programs, that if the defendant, if the offended person, the victim, has a smartphone and that person comes to within the excluded area, they get a bulletin that they're within the protected area. That person can then call the police. That bulletin also goes to the police department at the same time. So that lady who may be at her home or may be at Walmart, she goes every Thursday night to shop. He knows that. He goes to the same Walmart. She gets a warning that he's within that 1 or 2 mile radius, and she has a way to protect. The benefit that I saw as a judge feeling incompetent in hearing these cases is it provides absolute proof who's lying, who's telling the truth. Now, if you can convince that man or that woman that you're taking over the case and they're no longer going to be the influential party and rule by fear, now that fear is on their foot. You violate this order and I'm going to put you in jail and I'm going to forget to let you out. Somebody, please remind me before I retire that he or she is over there and I need to let them go. So, I saw it as an opportunity to use technology to take control and develop proof that would, in effect, protect the woman. Secondly, my greatest complaint ever from my 9 years on the bench was no one had any money to do anything. They wouldn't pay their court costs, they wouldn't pay their attorneys, they wanted the state to provide everything except the bond. Bonding was never a problem. They always had money for bonds. So my suggestion to my friend, Representative Hardaway from Memphis, as we've talked about this and what brought this here, was to have this in lieu of bond in appropriate cases, and that person must pay in advance for a 30-day use of the bracelet as a condition of bond. Let me assure you that in 99% of the cases, that money is going to be there within a very few minutes. It may come from uncles or aunts or cousins or nephews, or it may come from a trust fund because it cuts across all lines. But that then provides us a way to fund this universally if the magistrate, who must be trained in this to make sure that we do it right, does that. So that's my concern. I thought the 12-hour cooling off period was a great idea. I think it had a fairly significant effect from what I saw. But my concern is that once you teach that person, you can't get away with this. And the next time you're back, it will not be to set a bond, it will be to set a term in jail. And you'll have to serve that. Once a judge that's interested, and I think the vast majority of them understand the seriousness of this and take it very personally, once we can give them the tools to make informed decisions with real proof, I think that would be a great benefit. So I don't know if you all have studied that any. I'm sure that, and I've got some great friends that are bondsmen in Hamilton County and some very good people. I'm not sure how they would feel about it. I haven't consulted with them. I got a feeling they may not like it too much. But I understand that. We are affecting their financial livelihoods. But when I was doing it, the average bond in this across the board was somewhere around $1,250 to $1,500. There were some $10,000 bonds, but there were a lot of $1,000 bonds. But if you could do this at the cost of and whoever it was that called me, I didn't take notes, their average fee was $9 a day. But I'm suggesting that we try to figure out some way to have the defendant in lieu of bond post that money, make that a condition of their own recognizance release, that you'll be released on your own recognizance, providing you enter into this contract with this company. There already is and this person also told me that there's already, I put it on my phone when she called me, some national app that's free to all domestic violence victims, and the only county at the time then participating was Memphis. And in Memphis, if a person goes in for domestic assault, the moment they step out of jail, that victim gets a text saying that he's been released. Well, I guess that's great. The victim gets to sleep 11 and a half hours good and then gets to go back on terror watch. But my idea was to continue that so that she or he would constantly be able to determine where they are. There are several companies that literally will project on your smartphone his or her location 100% of the time. And if they come within the area excluded by the judge, then the text warning is sent both to the sheriff of the county and to the victim. And I found that intriguing, and I thought what a great help that would have been to me when I was a judge. So those are just the practical applications, the narrow-minded view that I had of it. It is a very complicated issue, and I understand that. And I understand the lethality and all of those considerations. But the trouble is I can't predict what is in that offender's mind. And they may have never contemplated a homicide, but after I rough them up in the magistrate's office, 3 o'clock in the morning, I'm not happy to be there because they woke me up. I may say something to him, and that response may be toward that woman and not toward me or that man. So I'm very concerned that we approach this with a way that makes it possible that even if we have to start small and walk rather than run, I hope that we can find some way to make this work without putting our local governments in such a position that they simply, although they want to, will not be able to. And so those are a couple of questions or comments that I have on the subject. Others? Yeah, yes, Mayor.
I appreciate and echo your desire to have better evidence when we have to determine in the legal system who's telling the truth, because way too often, as you know, and some of us know, it's he said, she said, and you beat yourself saying, well, you know, who's telling the truth here, and you never really know. So I appreciate that. I think we should push forward with this statewide. I think it's a valuable tool to use. I just want us to be wise in how we do it and make sure we do it in the right way. And it may be, when we look at funding, I mean, oftentimes the frontline person and victims advocates, the ADA, maybe they need to be better trained, or we need to work with them through their CLE or whatever it is, that they need to be better able to ascertain when there's risk there. But I support absolutely what we're doing here. I think it's a great thing. Hopefully we'll figure out how to do it so that it's available to everybody and not just those that can afford it. So I didn't want what I said to indicate I didn't support this concept. I'm behind it 110%.
Other questions or comments?
Quick question, Chairman.
Yes, ma'am.
What is the percentage of, may not have that number, but percentage of domestic violence cases in the state of Tennessee?
Percentage.
Overall.
Well, so Appendix A.
I don't know. See, either one of those can be domestic assault.
So I don't think we have the number, like percentage of all crimes. We might be able to figure that out, but Appendix A shows intimate partner violence, not all domestic violence. So TBI has the data on offenses, and so that appendix shows by county the number of offenses and gives a total for each offense type, and we could also get overall domestic violence offenses, the number of offenses statewide.
Thank you.
And yeah.
Oh, Mayor McDonald?
I know in one of the studies we did, we looked at it on the basis of simple assault because that's where most of those cases are heard, or that's the way they're written up by the police officer, which is what creates that document. So I don't know about looking at all types of crime. I'm not sure the purpose that you have. But if you look at simple assaults, especially since they added, it got to they add, not simple assault, the choking is now the next level besides simple assault, just regular assault, I suppose, used to, but anyway, those type assault, it was a high percentage number, but that can be
get that.
gotten.
Yeah, we can get that.
Doctor?
So something you said, Mr. Chairman, made me think of one part of the report that we didn't go into as much detail here, but that I know the team spent some time studying. When you mentioned the pinging, where both the accused and the victim would have cell phones, and it would let them know when they were in proximity. I know that's something we looked at, procedures like that. And Jen, if you could talk to a minute about what the literature says about the importance of victims participating in the program, but then also about how the funding challenges related to that.
Well, like I said earlier, it's really important that victims participate in a program. That domestic violence is complex, and because the victim and offender are in an intimate relationship, it's more important than other crimes that the victim is involved in a program. So, but it also is more, requires more resources, and it's more labor intensive to keep them involved. And Cliff, were you referring to more about the alerts that go out to the victim?
Yeah, in terms of cost, yes. And I know, for example, if I remember correctly, the program in Memphis, even though they had a separate grant that paid for the victims to have devices themselves to receive alerts. And if I remember right, they're continuing that portion of the program themselves, even though that's not covered by the indigent, the IEF fund. Am I remembering correctly?
Right. So under current law, victims are, the magistrate, if they're doing GPS monitoring, if they're going to assign or order that as a condition of bail, they also are required to talk with the victims, provide them information, gather information from them, and offer them to participate in the program by carrying a device. It's like a fob that they carry around with them. And that is more effective because then you can set an exclusion zone that moves around, and so as the victim is moving around, you can make sure the offender's staying away. So it's a mobile exclusion zone rather than a stationary one. But that requires more resources, obviously. So then you'll need to have the devices for the victims as well, and more, really more involvement to make sure the victims are educated on how that works. Another issue with victims being alerted about what the offender is doing is that the victims are already traumatized. And so a lot of victims advocates say that if the victim has a device or something on their cell phone that's alerting them, it actually increases their level of trauma potentially because they're consistently or very often being alerted. So that's something that Memphis had to figure out at the beginning of their program, was how often the alerts happen, both for the victims and for that law enforcement will be responding to. So figuring out that alert system, how to manage it, and also keep the victim in mind that if they're carrying around a device and they're being alerted pretty regularly, it's going to increase their level of fear potentially. So the funding for that as well, the victim's devices are about an extra $5 per device per day. So that's another cost that needs to be covered. In Memphis, their grant program is complete, and they are finishing their evaluation of their program. So I don't know exactly how they're proceeding yet. I know they're figuring that out, but they want to continue. They're going to continue with the program and want to continue giving the devices to the victims and increase the numbers. Not a lot of victims, it's totally voluntary for a victim to carry a device. And if they carry it for a while and they don't want to carry that device around anymore, they can just give it back. They don't have to. They can stop carrying it. So not a lot of victims choose to carry that device around, but most programs want to encourage, increase those numbers, encourage more victims to be involved that way. But it requires more effort and
I'm a little
resources.
confused about the victim being traumatized. If the offender is within an excluded area, that's a violation of his or her bond. Mm-hmm. And now, the person I was talking to was advocating, so it was the greatest thing since sliced bread, I'm sure. But it alerted the sheriff so that they could respond and make an arrest at that location. Because of the device, they could see exactly where he or she is located and drive right to them and make the arrest. But that person, the victim, would then know they are in danger. So, I'm a little confused as we're not going to traumatize them by giving them notice somebody's driving to kill them?
So it's a balancing act. That comes back to that coordinated system where everyone's communicating the same message with everyone involved and with the victim. So deciding when the law enforcement officer responds to an alert, what the level of risk is, requires some procedure, and that's what Memphis figured out at the beginning was, okay, which alerts do we need to respond to? Which ones are, an intentional violation, or the person was just driving through the exclusion zone. So determining which alerts to respond to, and then who receives that alert. So does law enforcement receive it, or does law enforcement and the victim receive it? So the victim doesn't have to be alerted every single time.
That's right.
So deciding which alerts are really important for that victim to receive, for them to stay safe, because not every single alert might not all be intentional on the offender's side or a dangerous situation. So making that determination is a really important part.
Just quickly, the example from Memphis was somebody driving on the interstate.
Get on the mic, Dave, if you don't mind.
David Lewis, research manager on staff. The example in Memphis that they talked about quite a bit was someone didn't realize that the interstate was like the edge of the exclusion zone. So they were triggering an alert every time they were going to work or whatever. And law enforcement had to make a determination of whether there was ill intent. And in some cases, there was no ill intent. They literally didn't understand they were violating the exclusion zone. So that throws another wrinkle into the mix. So it creates a level of, do we sanction somebody every time, or do we take into account intent, which, is a policy.
What if we just don't put the interstate in the zone?
That's a very good, I would think the technology should be there. You could exclude an interstate.
So deciding where those exclusion zones is another important part of the process, and magistrates are required to, if the victim is present, gather as much information for them as possible to set up good appropriate exclusion zones. And they can be modified, and Memphis did that a lot, where they modified the zones throughout the time period. But that takes a lot of people to stay on top of that and be managing the situation as it evolves over time.
Other questions, comments? Do you have a question, Mayor? I did. Go ahead.
Thank you, Chairman. And I'm going to echo some of the comments from Mayor McDonald and Chairman Carter as well. I think some of the options of funding, if you did it in lieu of bond and in place of bond, I think some of those things could get worked out. There's a lot of that conversation in the draft report. But one of the things that I'm concerned about was a comment that was made earlier by both Mayor Bickers and Chairman Carter about actually using it as a tool. We in Bradley County are constantly concerned about budgets and how much it's costing to incarcerate people. So we were blessed in 2017 to build a workhouse, which houses 128 people. And as of July this year, only 72 people are housed there.
Wow.
We still can't figure out why our system is not working. We have empty beds at a lower cost facility than our overcrowded jail, which the state of Tennessee is citing us for overcrowding. But yet somewhere in the system, and whether it's training or whether it's just simply the understanding of this is a very effective tool in our toolbox. So I'm going to echo the request for emphasis on the training, whether that's at the court level, whether that's at the ADA level, whether that's at a commissioner level, I'm not sure. But clearly, Houston, we have a problem. I'll just personalize it. Cleveland, we have a problem. And I would love for that to be talked about also. Thank you.
Mr. Chairman. Thank you. Other questions or comments? Well, this is the first draft report, is it? Mm-hmm. Yes. So What's the will of the body? Would you like to have some more detail about what technology is available and what the cost is, what we can do about it? Does that interest anyone at the next meeting, or do you want to just? We need to talk about cost. We need to talk about what's available. You know, there's some 12-year-old kid in his grandmother's basement fooling with a computer. It's going to figure out how to do this cheaper next week if we'll give him a shot. So I'm very interested in what's available because I'm so far behind in what is available and what is not available. Pinging a cell phone is Stone Age technology compared to what can happen now. I just don't have any idea what's out there. The call that I got from, I think it was Utah or Wyoming, was 2-3 years ago now, when Representative Hardaway and I were working on a case out in Shelby County. So if you have interest in that, could we ask you all to put some folks together for the next meeting, maybe have a panel to have some discussion, or what's the will of the Mayor McDonald?
Yeah, I was just thinking that perhaps we could have a representative from the Memphis-Shelby County pilot and let them come talk about their experience to us directly, where we could have some interaction with them, as well as perhaps a vendor.
Could you?
We'd be happy to invite someone from Memphis-Shelby County and also maybe a vendor, set up a panel. My only concern is I'm just trying to remember there may be a statutory due date on this one, which I believe is January 2020.
The statutory due date was extended 1 month to February of 2020.
Oh, okay, so we could do that and then actually hear the final report
In
at our
January.
January meeting and still meet the due date. So that would be, sure.
Well, this is just really important to all of us, and particularly all the victims out there, and it's a serious, serious matter. So I really appreciate the hard work you all have done. I don't remember when I was up 2-3 weeks ago, and I sat down and I told you how simple it was, and you explained it was not, and I'm afraid you were right as usual. So nothing simple about it, but that's no reason for us not to dig into it and try and get to a good solution. So if you all will do that for us and come back, do you mind doing that? Is that the will of the body? I don't guess we need a motion for that, but, all right. Thank you so much, Ms. Berry.
Thank you.
Any other questions or comments before we let her step down? All right. Is that today's? Okay.
We have a little bit forward tomorrow because of the panels.
Mm-hmm.
And we could easily go through a candidate, but I know there's some stakeholders who probably want to be here.
Yeah, I hate to. We've gotten through a little sooner today than we'd planned. Tomorrow we have several panels. It's going to be a little longer tomorrow. I'd like to move something from today till tomorrow. We had one we thought we could, but there are some stakeholders coming tomorrow, so let's don't do that to them. So tomorrow may be a little longer than that. Any other questions or comments from any card tricks? As the mayor said, if you know any new card tricks, he makes all the money on the side showing card tricks. Yeah, all right. Well, ladies and gentlemen, if there's nothing else to come before the committee, will be adjourned till 8:30 in the morning. Thank you so much. Yeah, you're free to leave your books in here, and we'll lock the door and get them tomorrow.